Hello, this is Elliot Schlissel, Father's Rights Lawyer. Today we're going to talk about child protective services and child abuse. Most child abuse allegations coming into Child Protective Services and Long Island and by the Association for Child Services in the City of New York are made by anonymous phone calls on child abuse hotlines. On a national basis, about 3.5 million reports of child abuse are made each year to child protection agencies on anonymous phone calls. The large majority are phony or trivial. Many states have screening processes to determine which claims of child abuse should be followed up and which should be ignored. Child protection agencies have a job to see to it that children are protected. However, what child protection agencies shouldn't do is intervene in the private lives of families where there is actually no child abuse. Unfortunately, in the state of New York, child abuse investigative agencies are on the side of caution in virtually all cases. Part of the reason for their overly aggressive behavior of child abuse investigators has to do with the fact that they are forced to make significant decisions regarding the health and welfare of children with limited information being provided to them. Child abuse investigations receive information of alleged child abuse, child neglect, and assign a social worker to look into the family circumstances involved in these cases. Proceedings can be brought in the family court in New York State for alleged child abuse and child neglect. These proceedings can result in the removal of a child from the custody of the parent. The issue investigators and social workers for child protection agencies have to make is determining whether the parents are mistreating their children, or is this simply a situation where the parents are trying to do the right thing. My office has been involved in numerous cases involving allegations of child abuse. And in many situations, we have found that the allegations are trivial or involve overzealous reporting by police, teachers, or third parties. Let's talk about screenings. Since New York does not conduct screenings, there is a tendency by social workers and investigators for child abuse agencies to file child abuse claims in virtually every situation where an anonymous call is made. Now, if a child abuse allegation is filed against you, a report is prepared, and the report is either stated as indicated or not indicated. Indicated means there is belief there is either child abuse or child neglect, and non-indicated believes that they have not found child abuse or child neglect. These reports are filed in Albany. When a report is filed that says an individual is indicated for child abuse, there is a 60-day period where an appeal can be made challenging the findings of child abuse. If within that period that the appeal is not made, the material in Albany becomes permanent. A finding of indicating that there is an indicated situation involving child abuse or child neglect can have a terrible impact on the parents' lives. In situations where the parents believe that they have not done anything wrong, they should contact competent legal counsel, appeal the decision, and take it to a hearing. My office has been involved in doing these hearings for more than 35 years, and in most of the circumstances where the parents really haven't done anything wrong, we have been successful in eliminating the indicated statements in Albany against him. In other cases, we work out settlements where the parents take parenting courses and the statements involving alleged child support, child abuse, or child neglect are modified. This is Elliot Schlissel, signing off today.